Me. Maybe not. We've got several points.
Yeah, silly years if I run out of ink.
Bring two.
Going to, is that it?
I could just order one new box of these.
I've read enough letters from you by
I
now.
have a bunch at home, but I asked Lori, can you get Daniel order a box for me? I might not use them all in 4.5 months, but that looks pretty well too.
She chose to answer what she wanted instead of what it was asked.
I have no idea what that is though. Before I got it. Yeah. I must have been there.
Okay, folks, please remain seated. Come to order. Court is now in session.
All right, thank you. We are back on the record in the habeas, in re Scott Peterson habeas petition. Mr. David Harris,
Thank you.
you may continue.
Your Honor, the court this morning had also suggested that the people answer some questions as we go through this. So I wanted to, before I go back into the argument, answer some of those questions if I may. The court had asked a question about whether the past or present tense of the question, form of the question makes a difference. And we had cited in one of our briefings the Henderson case, and within the Henderson case is a subsite to a case called People versus Majors. And that's 18 Cal 4th 385 at page 420. In that particular case, a juror was asked in his questionnaire about whether he knew someone who was a drug dealer. And he responded no to the question, the form of the question, but it turned out that his wife, when she was a juvenile, had been involved in somewhat of that activity. As part of the evidentiary hearing, he had testified that he didn't know that, he didn't know her at the time that that happened. And so the court said, quote, more importantly, question 51A was clearly phrased in the present tense. We cannot fault Moore's decision to respond to the question as it was phrased. So you do have a case that's very specifically responsive to the court's question about the tense of the question makes a difference because the person is not necessarily being incorrect or false or erroneous or lying if they're treating it exactly as it is written and as that particular court found. The court also asked in a completely separate issue about if there was in the record any evidence of the race of Mr. Whiteside. So we would point to the court to exhibit number 8.
I did find it.
All right.
There's 8, and then there was, I think it was 13. Wait.
Well, specifically just for the speed of the record, Exhibit 8 has the face sheet, which is from the East Palo Alto Police Department, which has the arrest information for Mr. Whiteside, which does include a box indicating his race.
Okay, thank you.
Also, one of the other questions the court was talking about and potentially suggesting in future briefing dealing with about the definition in the past of what harassment was. So we wanted to try and address that now based on the slide that was presented. That particular slide was quoting from CCP 527.6, and Mr. Gardner had explained what harassment meant, and there was an indication that he the inference was that it was unlawful versus the tort versus the crime. So as what I was seeing on the slide that was up on the particular screen is the slide said, after the first part, which could be potentially criminal, it said, or knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses. So even under that definition that's provided from that section, that doesn't necessarily mean criminal conduct. So we make that distinction for the court because as we go through and talk about these incidents, we have the lawsuit, which the petitioner does tend to take that and create that going from a lawsuit to that conduct being criminal in nature as well. And as we pointed out repeatedly and Ms. Nice has testified to, she did not view that as being criminal behavior. It was a civil proceeding. It was not criminal. She could have called the police and she didn't. It didn't happen relating to that. So going back to where I had left off, specifically Ms. Nice had testified when she had completed the questionnaire and talking about the restraining order or anything else, it didn't cross my mind. When questioned, even though you were in the same courthouse that it happened, Ms. Nice explained, yeah, it didn't cross my mind. I just don't hold on to things. I didn't remember. It didn't cross my mind. Ms. Nice further elaborated saying, that was over. I don't hold grudges. It was past me. And that's back in Reporter's Transcripts, page 84 through page 85. Now, one of the things that the court can take from that particular exhibit, when we were looking at the Exhibit 1 dealing with the restraining order, is that's the first example that the court has physical proof Ms. Nice is not very good at filling out forms. She was specifically asked on that particular exhibit, who did you put down as your attorney? And she was asked on page 259 of the transcripts, in that particular document, you filled out, looking up at the top of the box where it says, attorney or party without attorney, whose information is written in there? And she puts Marcella's. And did you write that in there? Yep. Was she your attorney? No. So we have, even before she ever comes in with that little summons for jury service that you put on her refrigerator, proof that she has a tough time filling out forms. So she put the wrong person in the wrong place for something that was in that particular record. Was she lying about that? Was it false? It's wrong, but there's no intent on her part to really try and say that Ms. Kinsey was her attorney. She just filled the form out incorrectly. Counsel was talking about how that process of the restraining order, kind of dovetailing into this, was a crime, and she should have reported that because the circumstances of the events that led up to this. So I just want to take another quote, and this is from the Reporter's Transcript at page 47-48. Ms. Nice testified, okay, so had Marcella not continued to bother me, so this is after the September incident, I would have never filed a restraining order based on these facts. So since she did, I did add that in there because I knew it was showing history of her being a little stalkerish. So I put it all in there. But again, had she not continued after that day, this day, if you see the restraining order was filed a couple months later, if she had stopped, I would have never filed a restraining order. So as the court has already mentioned, the circumstances of Kinsey showing at her ex-boyfriend's house is one particular incident where the people's position is Miss Kinsey was not I'm sorry, we just had a screensaver pop up there. So she's not a victim in those particular circumstances. It's the additional conduct, the fact that she continues to be bothered by Miss Kinsey, which is what causes her to get the restraining order. It's not based on claimed criminal conduct that happens in September. And again, dealing with I know the court had asked a question, and I had addressed this before lunch, the difference between the first civil restraining order and the potential possible suit, the second issue. Regardless of that, Ms. Nice was asked about the Marcella suit being dropped. And I recall dropped being the language that she used several times in her testimony. And we pointed out in our briefing because that's consistent with somebody wanting to drop criminal charges. She stated that when she completed the questionnaire, she never thought about it at all. So again, that's the reporter's transcript 302. Now, so we have this background information. We talked about the law. Has the petitioner met his burden of shifting the circumstance, shifting the burden to the people to prove that there is a rebuttable presumption that Ms. Nice had done something wrong? And part of that argument that they say the court should look at, the totality of the picture, as they were trying to say, is because of certain things that she lied, she was granted immunity, and the court kind of raised those, or talked about those issues. But one of the things that we want to point out, and the court has already mentioned this, but we're going to give you some additional law on this particular point. The court had said one witness is sufficient to prove a particular point. Now, early on in briefing, the petitioner had said, well, you really can't trust a juror. You know, how can they say that they shouldn't be, they can't say that they weren't biased. You just can't really go there. So we're going to start by talking with the U.S. Supreme Court's case of Smith versus Phillips. In that particular case, the court rejected that very argument that the trial court cannot possibly ascertain the impartiality of a juror by relying solely on the testimony of the juror in question. So you have that particular case that says you can use that juror to decide whether they're telling the truth or not. And that's what this evidentiary hearing was about, is for Ms. Nice to come in and explain how she answered this questionnaire all these many years ago. Now, the Smith case is not the sole case. We also cited in our briefing the People versus Cochran. And in that particular case, one of the cases cited by the defense relied upon them heavily is the Diaz case. And the Cochran case said, we, unlike the court in Diaz, take the statements of the jurors that they could set aside this knowledge, in this particular case of a family, and judge the case fairly and impartially at face value. We decline to evaluate and subsequently dismiss such statements by jurors as self-serving, as did our colleagues in the Diaz case. Going further into more recently, in the Cowan case, Supreme Court said the referee was entitled to credit the juror's sworn testimony at the hearing on this point versus other unsworn hearsay statements of the officer's report. And that case is assisted in this particular circumstance because in that particular case, the petitioner had subpoenaed one of the involved officers in their issue. That officer was sitting in the courtroom, but they never called the officer to testify. Yet they referred to police reports and other things, and they didn't put the officer on the stand. So in this particular case, what we have, counsel referred to them as these, the contemporaneous documents. But as the court will recall, you've now just looked again at Exhibit 8, which is the face sheet. That is not a contemporaneous document. Ms. Brackshaw has testified to that particular document being generated 20 years after the fact. And in fact, when she talked about it, there's a box on there that says when it's generated, and it was 2022. She talked about how she was not sure how that information even ended up in the system. Somebody had to put it in there. She wasn't sure. You recall her testimony about these particular documents and where they came from. So those contemporaneous documents are not very supportive of the petitioner's position. They've relied constantly on an accusation that was filed against Mr. Whiteside. They talked about the complaint. Here's all the things he was charged with. It would be so nice if it was easy to prove just by referring to the complaint that somebody was guilty because they just filed the complaint. It would make my job a whole lot easier if that's all that I had to do. But we know that's not how it works. And in fact, all of those charges are irrelevant because Mr. Whiteside didn't plead guilty to any of them. There was an additional count that was added, and he pled no contest. As the court will recall, we had that discussion throughout the evidentiary hearing, and that was the end of it. We would be required to speculate at best to figure out why Mr. Whiteside, assuming what petitioner is saying is true, why he might plead guilty if, as in fact, he was innocent of the charge. Again, the people could come up with lots of different reasons why that might be, or the fact might be that he really was guilty and he took a deal that was offered and that was the end of the discussion.
So his plea was NOLA, right?
Correct.
Is that significant? And if so, why? Versus guilty?
The only thing that
Go ahead.
legally, it makes no difference. As Pat Harris pointed out, the code section that says, for all purposes, from legal purposes, the fact that it's no lower, no contest makes no difference. It's still treated as being guilty. That's the standard instruction as part of a plea the judge would read to that individual. However, the reality of dealing with criminal cases, we know sometimes defense attorneys will talk to their clients and say it's a no contest plea, you're really not admitting it. Again, we're getting into the area of speculation, which we'll keep reminding the court we gain nothing by speculating when we have the facts before us in this particular case.
All right.
In this particular case, what we do know is that Ms. Nice came into court, the only witness on this particular point that came into court. She addressed this particular issue, and she said he didn't do it. So that's the evidence before the court. And again, it doesn't matter because the question, as she said, she didn't think about this particular issue, but the question wasn't asking whether she would have been a defendant or she would have been arrested. It was completely different, and we're going to go through that in just 1 second. But to be clear about this, the Cowan case is significant. This also came up during some of the testimony. The Cowan case, the referee was entitled to credit the juror's sworn testimony, said the officers, as I mentioned. And the fact that the juror in question did not remember that they had been fighting in public did not cross his mind was sufficient by that particular denial for the referee to find that there was no misconduct. The court had addressed the issue of immunity, so I just want to add one note to that particular area. The California Supreme Court, in the case of People v. Lucas, they've addressed this about witnesses wanting immunity. And the quote from that particular case is, "Innocent persons, as well as the guilty, are entitled to invoke the privilege. As the High Court has declared, the privilege serves to protect the innocent, who otherwise might be ensnared by ambiguous circumstances." So again, we have the law saying you can't look at this immunity. Ms. Nice could have been asked, why is it that you need this? But the mere fact that she asked for immunity is not something of substance that helps the court get to any particular place.
Well, how do you address the fact that Mr. Gardner raised that, she all of a sudden stopped cooperating? So she spoke to the Habeas Corpus Resource Center investigator in 2015.
Correct, and I think the circumstances there, to use the example that Mr. Gardner used, is when he was citing to the Manriquez case, he talks about it's one step forward because the person volunteered in that particular case. But the fact that the person doesn't step forward does not mean that they're taking a step back. The failure of something is not necessarily a negative. So in this particular case, what we do know is Ms. Nice gave statements, did interviews, and in 2015, when one of the Habeas Corpus Resource Center investigators showed up, she talked to them. She gave them a statement, and we went through the whole issue of the notes that she used to review refresh her recollection. There was no declaration that came with it, so we're not exactly sure what was said, but we had the notes that she could figure out the date from. From that, she learned that she's being accused of misconduct, potentially that could result in a new trial for Mr. Peterson. We know that the information becomes public after that, as Mr. Gardner indicated, it was filed as part of the petition. It's reasonable for a person to get a lawyer if somebody's accused. That's what happens these days. Anybody who's accused of things, they get a lawyer. Lawyers give them advice on what to do. To speculate why those things happen, again, going back to we're speculating. What we do know is she talked to them when she wasn't being accused of wrongdoing. Once she's accused of wrongdoing, her obligation by law, because the Hamilton case says jurors have a statutory right to refuse an interview. She didn't have to talk to them. She has an obligation to come to court when she's subpoenaed and testify truthfully. That's it. So this is not a negative against her. It may not be what they want, that they could have deposed her or talked to her or had many more interviews, but it doesn't prove a negative. It just
Well, to get to the point about depositions, Mr. Gardner and company did ask the court for leave to depose Ms. Neese, I believe it was Ms. Neese, her mother, Mr. Whiteside, and the people opposed the motion. The court denied the request. But, you're bringing this up now, well, they could have done this and that, but the people took the position that I shouldn't allow the discovery.
And we still have that position because the reason, as we explained that point in time, is this court needs to sit and watch Ms. Nice testify because you're the determiner of whether she's credible or not.
But what about Mr. Whiteside?
In that particular case, you need to see him as well, that based on the claims that they were saying he was going to come into court and say, he needed to come into court and say.
Okay.
So one of the things, I point this out, there's the case of People versus Henderson. The Henderson case is a circumstance where the Court of Appeals, in that particular case, at 78 Cal. 5th, 530, in this particular area is at 563 and 564. A juror in that particular case ended up, I think it was in a coffee shop, sitting next to a defense lawyer who was not part of the trial but knew who was involved in the trial. There was some brief, innocuous conversation, but that attorney brought it to the court's attention. The court brought in juror number 2 and they had a discussion. The juror, when asked about what was said, didn't recall what was said. And the court immediately went to thinking something, presuming, because the fact that he didn't remember it, that it was bad. So the Henderson case says that under the demonstrable reality test, courts may not presume the worst of a juror.
Slow down when you're quoting for the court reporter, please. Thank you.
So I'll repeat it again. And the court was not entitled to do so by presuming the worst. Such a presumption, however well motivated, does not furnish the good cause required by the governing statutes. So thus the trial court erred in excusing the alternate in that particular case. Because the fact that the witness may not remember something doesn't get you to the point of saying that the witness is lying. Now, if the court would have found them to not be telling the truth, that would be something different. So that's when the petitioner shifted, saying, well, immunity is one thing. Here's all these statements in her declaration. So let's go through her declaration and say where she's making things up. First, we want to start with, the court will recall the beginning of her testimony. She was asked about her declaration pretty much paragraph by Pat Harris. And it was, is this true? Is it true and accurate? And she would say yes. But she got to a particular point and she would say, not so much, or something's wrong with that. And she ultimately said that there were some paragraphs that were wrongly worded. And so she wanted to correct those particular paragraphs, and she did as they went through it. Now, to answer another one of the court's questions about how the exchange worked, where she was doing this declaration. She testified at reported transcript 222 that when preparing this particular declaration, it's with COVID, it was a bit hard. When you don't get to meet with somebody in person and everything is done over the phone or Zoom, so I think a lot of things get mixed up. And I probably should have sat down in person with this attorney, but everything was done over the phone, Zoom, and emails. And that's, quote, specifically at reported transcript 300, line 3 through 12. So you have the witness explaining to you, here's the process, the declaration is created, I sign it, I should have maybe gone over a little bit more to make sure it's clear, but as we go through this, is it true and correct? I'm going to tell you where I find some mistakes as she's reading it. And that's what she's doing. She's clarifying her declaration. Again, she's not lying. As things, as she said, as things were explained to her, as things became more known to her, she would say, well, maybe not that way. Maybe it should have been this particular way. However, one of the things that she did clarify, and I think this is of significance because it shows the honesty of Ms. Nice, is one of the paragraphs she corrected, and this is page 33 in the transcript. She said, before the trial, I didn't have any anger or resentment towards Scott at all. After the trial, it was a bit different because I sat through the entire trial and listened to the evidence. And because of that, she said as to paragraph 31, it was wrongly worded as to not having any bias after the trial. And she explained that. So again, the fact that she corrects and clarifies something does not necessarily mean that she was lying before. It just means that she may not be articulate, or she may not have completely understood, just like her jury questionnaire. She was not alone with having that problem. The court will recall Ms. Bractures and the conversations I had with her. Ms. Bractures produced 2 separate declarations on exactly the same point. One declaration, she said, she testified that she was the person who created the document. And this is a woman who had 10 years of experience as the custodian of records. This was her job. She's received training in how to respond to subpoenas. And then she submitted a second declaration where she said it was Officer Corpez who was the person who created the document. And more illusory or illustrative of this particular issue is the fact that both of those declarations were prepared for her by the Habeas Corpus Resource Center. So you have 2 documents covering the same grounds that are diametrically opposed. So it's unlike what Mr. Gardner was saying, there's a chasm between some of Ms. Nice's answer. This is an impossibility between Ms. Bractures. But we're not saying that she's a liar. She said, I didn't really understand, but she did testify the second one, Officer Corpus's, that was more accurate. So if we were to look at the circumstances of the credibility test that you were being asked to apply to Ms. Nice, and you apply that to Ms. Bracture, the court would have a lot less evidence. And we're not saying that that's the case. We're not, like I said, we're not saying that she lied. We're just saying that she didn't completely understand. And in Exhibit 9 is the SDT that was submitted by the Habeas Corpus Resource Center for the East Palo Alto Police Department. And it asks for any and all documents, whether electronically stored or otherwise, related to the November 2nd, 2001 arrest and prosecution of Eddie Whiteside III in case number EO1-306-17. This request includes documents stored in electronic databases and specifically the multi-agency RIM system. Now you'll recall Ms. Bracture's testimony, and the court's already looked this morning or this afternoon at the attachment to Exhibit 8, which is the face sheet. She testified when you submitted the subpoena under penalty of perjury, you turned over one record that existed for the Palo Alto Police Department in response to the subpoena. Is that correct? Her answer, correct. And that was page 518 of the transcript. So you have her telling you there is only one document. Except the unfortunate problem was she was shown other exhibits that came from her system that she printed out. And those are exhibits 23, 24, and 25. So we talked about that with her. And she was asked at page 534, did you have additional conversations after the subpoena with the attorneys? Answer, yes. Where you started to think over maybe you should have turned those things over? Answer, well, what they asked me for was to do the screenshots of each page that we had information on. And so that's when I presented the screenshots to him. And that was because they received, I guess, something from the DA's office that had screenshots. And that's when they asked me if we had anything that we could provide, if we had that. So that's when I provided it. I didn't even think that I needed to do that at first. Question, it just never crossed your mind to submit those particular items to them? Answer, no. They just asked for reports. I printed what we had, which was just a face sheet. So you have a trained expert witness dealing with her area of expertise who gets it wrong, doesn't comply with the subpoena, submits not all of the records that she should have because it just never crossed her mind. She didn't think that that's what they were looking for. The people don't submit that Ms. Bracture was lying. We submit that she did the best she could based on what she thought was being requested. There is no difference between what she did and what Ms. Nice did with her jury questionnaire back all those many years ago. It just never crossed her mind. She was mistaken. So, excuse me. So petitioner wants the court to say, okay, forget that there might have been mistakes. The fact that she said that she was spiteful, there's the bias that comes out. So again, we would submit to the court the fact that petitioner is just jumping right to the bias is a concession on their part that, assuming that they have met their initial burden, which we still don't concede that they have, it's been rebutted by the testimony of Ms. Nice, who said, I didn't think about this, these things never crossed my mind, I did the best that I could, even though I'm really bad at filling out forms. So now we have this circumstance where, oh, she was spiteful.
I'm sorry, did Ms. Nice say she was bad about filling out
Yeah,
forms?
I'm sorry, that's my quote, yes.
Correct, she never said that on the record.
I'll just show the court the evidence of her being bad at filling out the forms.
All right, but there is a distinction that's
Yes.
important. All right, thank you.
So the petitioner uses the word spiteful to Ms. Kinsey. So in the transcript, the reporter's transcript, that particular word, spite, is used 8 separate times. Page 52, page 53, page 195, 296, and 297. The problem with it, again, goes back to the questions about the case where the judge couldn't take the coffee shop conversation about the juror and instantly go to a bad place. There was never a follow-up question. There was never a follow-up question that said or asked, was it not true? Was it false? Was it not truthful? Was it not accurate? Was it a lie? Instead, it was spiteful. You can be spiteful and still be true. So again, it was incumbent upon the petitioner to follow up those questions and find out if, in fact, they were a lie. Just because you want to assume that it is does not make it a lie. And as I said in the Henderson case, you can't presume the worst. Now, the court did mention the circumstance of where Ms. Nice had contacted somebody from law enforcement about seeing the video. So that was goes to page 194 and 195 where she explains that particular thing. And there was an interesting conversation that came in that particular line of questioning where Ms. Nice was asked, was the restraining order for both you and your unborn child? Answer, yeah, but he was born at that time. Okay, question. And so you understood that, well, let me ask you, did you understand that once your child was born, the restraining order was over? Answer, no, I still had the restraining order. Question, restraining order was over for your child? It no longer applied? Answer, I don't know. I'm not a lawyer. I don't know. So during this particular time period, Ms. Nice doesn't even really know, it appears from what her testimony is, whether that restraining order is still valid or not. She just was spiteful at the moment and contacted somebody because she saw Ms. Kinsey with your child in this video.
There's nothing in the record that indicates that the police were called up. She contacted someone, but there's no record evidence that there was a phone call made to 911 or
Correct.
anything like that. Okay, thank you.
So the next area that the petitioner has tried to claim that here's proof that Ms. Nice was lying is they have marked as an exhibit. It wasn't discussed this morning, but I want to just touch briefly about this because it's significant for another reason, and that's exhibit number 5, or excuse me, exhibit 16, dealing with the child support issues.
Just a moment, please. Okay, I did not, at the time, Mr. Gardner, correct you. She didn't file for child support. It's the Department of Child Support Services that they're the attorney on the document. But you would agree?
I do agree, Your Honor.
Okay, thank you. Go ahead.
So that particular exhibit has 2 separate requests, or under 2 separate case numbers, where there is a filing for child support. And the reason I bring this up is because there's 2 additional circumstances in those particular documents showing that Ms. Nice is not very good at filling out forms. That's the simplest way to put it. There was one that she discussed when she was on the stand, and that's dealing with question 5E. where she put down that she had spousal support of $400, and then she said something to the effect of that she never had spousal support. She filled that out wrong. And that's on the reporter's transcript, page 117. So that was one that we know about, where she's saying she's filling out a form, but she's got it wrong. There's another one, Exhibit 16, question 19C.
Just a moment. What page? 4?
Unfortunately, those are not numbered, and there's 2 separate case numbers under that exhibit.
So 19C is the special hardships expenses for minor children? Is that the one?
Correct. And the C question is, these expenses listed in A, B, and C create an extreme financial hardship because, and then parentheses, it says explain. On both of those particular forms, Ms. Nice did not answer the question. So once again, even though she's claiming something relating to that particular question, she didn't explain it. So I bring this to the court's attention because this is the second and third time in the record that we have Ms. Nice not being able to complete a form correctly. These are matters that have nothing to do with Scott Peterson. These are matters that relate to complete different issues, different courts, different subjects, showing that, like I said, she's just not very good at filling out forms. The court has already pointed out a couple of additional things in her questionnaire relating to this particular case, where she just wasn't good at getting the answers down. But there's no showing at any point in time that she is lying about this. There's no showing. And there's a fine line, we discussed this in some of our original briefing, between intent, falsity, and lying. What is really meant by that? What we're saying is that she's wrong. And I would disagree with Mr. Gardner about this when it comes to the chasm of distance between whether something is false or whether it's erroneous. The fact that it may not be completely accurate doesn't mean that it's a lie. If she's doing the best that she can, but she doesn't know how to fill out a form, or she makes a mistake, doesn't make her a liar, doesn't show that she is intentionally doing anything. Which takes us back to Manriquez. Manriquez basically said an unintentional violation may be sufficient to overcome the amount of prejudice by itself. So now moving on to the second question, the more nuanced question as Mr. Gardner was talking about, which is question 74, whether Ms. Nice was a victim or a witness in all of these multiplicity of things. I'm just going to go through this really fast because the court's heard a lot about this. I disagree with Mr. Gardner when he's talking about a first-year law student and a door, whether she's a victim or not. Again, this wasn't her door. As the court indicated, she testified that she went upstairs when this incident happened. She told Eddie that somebody was outside for her. So she did not see this particular circumstance happen. It's not her door. It was her landlord's door of her mother's house where her mother is on the lease. So if we wanted to stress it further to say, well, anytime that somebody in the house, you could be a victim too, or you may have known something, that's a little bit far. Does it make it reasonable when she doesn't put that down in her questionnaire? The tires. She specifically was asked that particular question on page 56 of the transcript when she thought that Miss Kinsey slashing the tires to be a crime. Miss Nice responded, it wasn't a crime against me. They weren't her tires. She didn't see it. She wasn't there. Stalking. Again, we could spend a lot of time with that. Stalking appears in different forms 6 separate times in the reporter's transcripts of the evidentiary hearing. And it goes back to the statement I read before where she was saying she put that information to show kind of the stalkerish history of Miss Kinsey when she was applying for that restraining order, and that's at reporter's transcript 48. Clearly, she is not referring to stalking as a crime as we would define it under Penal Code 646.9, which has a very specific definition, which has years of cases that explain how that particular case or crime section should be interpreted. We have her using this in a very generic circumstances where she's talking about how Miss Kinsey followed her and made faces at her that she saw in her rearview mirror. The phone conversation, as I recall, the phone conversation is actually not in evidence. What happened was she was asked the question, did you put that in your declaration? Nobody ever asked the follow-up question, whether that was true or not. So we don't know who called. We don't know how she knew it was Ms. Kinsey that was calling. So we're just left to assume certain things again. As the court was indicating, there's a broad spectrum of what threats are. So then we get to the next level of what she potentially could be a victim of. When she was getting this civil order, she wasn't being threatened. She talked about that. We've covered it a number of times where she said she didn't want to be stupid and roll around the gutter when she was pregnant. She didn't say Ms. Kinsey was coming out and threatening her. She said what she was saying, asking me to come out, she knew what would happen from that. That is not a threat. That does not make her a victim. So the last area...
Can I go back just for a moment?
Sure.
To Exhibit 16, the child support. It was the Department of Child Support Services that were her attorney. I understand that. But if you look at the September 8th, 2004, actually both forms, and these are forms, the Judicial Council family law forms, they're filled out every day in family law cases and support cases. But on, these are not Bates numbered. So on the September 8th, 2004 filing, income and expense declaration, she doesn't on this form list any spousal support from a different marriage, correct?
Correct.
Okay. And then on item 12, the following people live with me. She doesn't list her mother, correct?
Correct.
She doesn't list Eddie Whiteside, correct?
Correct.
Okay. But they did live with her at the time.
Again,
Okay, but that's a yes or no question. Did they live with her at the time?
well, actually, I would disagree with the court that it is a yes or no question because the way that the court phrased it versus the way that it's written in the question, and that's what we think is significant. Did she live with them or did they live with her?
Okay. And then going on to the next page, item 20. She writes, the question is, other information I want the court to know concerning my case. She says, I may be out of work for the next 5 to 6 months due to jury duty in San Mateo County. I'm a prospective juror on, or in, I can't read, a major case. What significance, if at all, does that statement have vis-a-vis what she told the trial judge about the finances are taken care of? I've talked with my family, everything's fine.
Well, I think the circumstances are, again, looking at how this plays out in terms of sequence. The first sequence we have is when she comes in to fill out the questionnaire.
Okay.
Then we have her reporting back for the voir dire where she's present with Mr. Garrigus and the judge.
So it was March was the questionnaire.
Correct.
When did she come back? Let's see, transcript is at 5, and that is, I don't have a date on it. So I don't have the cover sheet, but it's at Exhibit 5. Do you remember when it was?
Off the top of my head, I believe that the court looks at the questionnaire. There is a date written on it.
All right, but they could have come back at different times. But it was before September 4th of 2004.
Yes.
Okay, go ahead.
So the sequence is she fills out the form, comes to court. At some point in time, those forms get filed by the Department of Child Support Services. And the court will note, because they both have separate signatures and dates, they're two separate dates. I believe they're about a month apart.
Okay. Go ahead.
So the first one, she does not make the statement about being a potential juror. The second one, she does make the statement about the potential juror, which would indicate that she's at least been through the process and she may end up being a juror. So again, she has new information, she's adding it to the form. In terms of the finance, the ultimate finance issue, the people would submit as a red herring. Because as we heard from her, Ms. Nice testified, and those documents tend to support, what happened was she got involved in some type of issue with her former employer. The former employer ended up paying her for the entire time that she was on jury duty. So there was no financial hardship. When you take things as a snapshot, you could say, well, this is different than this one, and so there's a problem, but we can see the progress just by looking at those two particular forms. First, she gets the spousal support wrong. A month later, she fixes it. She doesn't have information about jury duty. Then she does, so she adds that in there. But bottom line, we see from those particular documents, she attached pay stubs that she was still getting from her employer. She testified, and there's been no challenge about this particular issue, that she continued to get paid throughout the trial based on the agreement that she reached with her employer.
Okay, so the first filing she signs on March the 26th. It's not filed until May 10th of 2004. And that's the one where she doesn't list anything about the trial, but she does put the $400 down for, excuse me, spousal support. The second one was filed on September the 8th, but it was signed, at least the signature page is April 17th, 2004. Okay, thank you.
So again, moving forward in terms of looking at her credibility as to these question 74, the specific subparts that petitioners raised, dealing with the DV issue, bottom line, it was petitioner, if they are going to claim that she was a domestic violence victim, the only witness that could dispute that, based on what Ms. Nice testified to, was Eddie Whiteside. Eddie Whiteside, as the court indicated, a subpoenaed witness, didn't get called. It shouldn't have been a surprise. They didn't need to do a deposition to say, did she hit you? Or did you hit her? So we can't, I don't want to beat this dead horse, but they have to lose on that particular point because they didn't produce the evidence. It's their burden to do it, and we'll move on from there. So the next one is, if she wasn't a victim, was she a witness? The two-part compound portion of this question. Again, their burden to prove. They talk about, and she spent a great deal of time on the stand about whether she was a witness because whether you hear it or not hear it. And she said she had gone upstairs. She never saw the door kicked or saw the tires slashed. In fact, the quote is, when Miss Nice and when Kinsey's cousin knocked on the door, and here's the quote, and they asked for Eddie, and I shut the door and went upstairs. I told Eddie he had a visitor. And that's at Reporter Transcript 182. Ms. Nice stated, that was 100 years ago, so I believe that's when she started yelling for Eddie to come outside. Reporter's Transcript 88. Ms. Nice never went downstairs when Ms. Kinsey was yelling for Eddie to come outside. Reporter Transcript 88, line 22 to 24. So she did not see the door get kicked. And she's asked specifically at page 64, line 19, when you checked no, did you have a different understanding of the phrase witness as to the slashing of tires, crime of slashing of tires? Answer, I didn't witness her do it. Question, okay, and that's my question is your understanding of witness that you actually have to physically see something? Answer, yes. Again, this is Ms. Nice testifying what her belief was, what her understanding was, and there's no showing that she's actually wrong. We can have a disagreement about that, but her interpretation is not unreasonable. So even if she should have said something because she didn't view it that way, she's not wrong. And there's a number of cases that we've previously cited that say that particular point for jurors. And I think it's significant because in her voir dire with Judge DeLucchi and Mark Garrigus asked a particular question. This is at page 4223, Exhibit 5, asking about whether there's some issue with their children, her children, and somebody comes running to you first. And her answer was at line 6. Answer, yeah. If I don't see it, I don't. Whoever comes running in tells me first. If I don't see it, I don't go with that, no. So even back when she's being selected as a juror, she's explaining her position that if she doesn't see it, she's not a witness. That doesn't make sense to her. And it explains the second and last portion of the witness aspect, which is the incident with Eddie Whiteside. She thought that that particular circumstance, she was asked about this, and the court may recall the particular question, were you outside of your body? Did you see this particular? And she's responding, no. In her mind, she was not a witness to this. She was actively involved. She couldn't see it, so therefore she wasn't a witness. And again, it may seem silly, it may seem different, but it's reasonable for her. The whole incident for whether she was a witness for, because she's alleged to have made the phone call on the Kinsey incident. And as we pointed out, our position on that is that she is a reporting party. She's not a witness. She's just calling something in because she believed that Whiteside told her to. So again, addressing all of those particular issues. The only thing, so her being a victim or a witness, there's no showing and there's been no proof by the defense, by the petitioner, that she actually was either a victim or a witness in these particular circumstances. Now, whether family members, which is the last component, the last compound portion of question 74, were victims or witnesses or family members a victim or a witness. So the circumstance that we have is we have Eddie Whiteside's tires get slashed. We've already gone through this where she says she did not see what happened, she didn't know what happened, she didn't follow through and participate in the particular criminal proceeding. That was another question that she was asked later on.
But she put it in her restraining order.
Well, she put in all of the facts in 2000 when that happened.
Okay.
And she also wrote it in the third person. That was part of the questioning that was asked as well. So the fact that she may have been told something to add it in there does not necessarily make her, she's not a victim or a witness, she's being told, and the people will submit, maybe she should have been aware that he was the victim of this particular tire slashing, of something that happened several years beforehand. But this is where the reasonableness comes in. The fact that, assuming that that's true, that she should have thought about that yeah, his tires got slashed a few years ago by the ex-girlfriend, I should remember that to put that down. You heard it from Ms. Nice, it didn't cross her mind. She doesn't think about those things. So was that a reasonable response for her to say, I wasn't thinking about something that was such a past incident. She doesn't hold on to those particular things. And I think that is reasonable when she says that she just never thought about it when she filled out her questionnaire. She's been unequivocal and steadfast in repeatedly denying any intentional withholding information. So that takes us to kind of whether the burden has been met by the defense. And I want to talk to the court about the Hamilton case, which was referring to the McDonough case. In that particular case, Hamilton's referring to McDonough, saying that to invalidate the result of a lengthy trial because of a juror's mistaken though honest response to a question is to insist on something closer to perfection than our judicial system can be expected to give. Even more recently, our Supreme Court, in the case of People v. Wilson, in this particular case, 2021 case, a juror forgot to mention that she had previously served on another, what she said was a capital murder case. So she's sitting on a new capital murder case and forgot that she'd been on one before. And that court said whether juror number 9's undisclosed prior service was a capital trial or a murder trial is beside the point. When assessing whether it is substantially likely a juror was actually biased, our inquiry is not whether the juror would have been stricken by one of the parties, but whether the juror's concealment or non-disclosure evidences bias. Juror number 9, inadvertent non-disclosure of her prior jury service did not evidence bias, and said the trial court was correct in denying the new trial motion. In this particular case, there's been no showing by the petitioner that Ms. Nice has done anything other than make mistakes. So, assuming that they met their burden, Ms. Nice's testimony, her declaration, and the entire record before the court has rebutted that particular presumption. So then it moves to the next phase. If the court wants to give them the benefit of the doubt and go to that particular point, it then becomes their burden, once the presumption is rebutted, to prove actual bias. And so I'm going to try and wrap this up real quick into what they've said about bias. The bias comes from her finances, that she was fixated on the little man, and that's based on the book, the letters, and Ms. Anderson's statement, and also that there was a preconceived verdict in this particular case. So just to go through these really quick. As we've already said about the finances, that's just not accurate. It's rank speculation because we know from the testimony that's not disputed, she got paid her entire time. Ms. Nice testified that when she made the statement to the court, it wasn't a lie. Mr. Whiteside and her mother were aware that Ms. Nice would be bringing in a very small amount during jury duty for money. That's at Reporter Transcript 122.
Will you slow down, please?
And again, had the petitioner wished to dispute those or disprove those particular points, it was incumbent upon them to bring in Whiteside as to those particular issues, the mother, or even in the case where they asked her, did you borrow $1,000? They could have brought in the juror that they claimed had loaned her the money. So again, going back to her finances, we've already talked about the income and expense declarations, unrelated matters to this particular case that can't show her bias in this case because there's no connection. So moving on to the book.
If I can, for a moment, these letters. The exhibits, let's see, we have, just a moment. Six, seven, no. I think they're all exhibit 6.
6 and 6A.
They've been admitted for state of mind, right?
Yes, looking at would cite the court to Reporter Transcript 388 for the court's ruling on that particular point.
Okay. How, if at all, should the court consider those letters?
Well, first I think we want to start with the circumstances of the letters. Ms. Nice testified that her therapist was the one that suggested that she write those. And that's, again, citing to the record at 253, lines 13 through 19, and 295, lines 4 through 8. These were written after the trial. So how did these letters connect back to, in fact, as part of the court's ruling on page 388, so the court indicated there was an objection because it's the state of mind, it's an issue. But again, I'm admitting these. You preserve the argument, Mr. David Harris, that the respondents do. The court should give very little weight to these letters. This is the discussion that we had when these were coming in. These are after-the-fact letters written at a suggestion from a mental health professional based on the issues that Ms. Nice was going through at the time, based on the evidence that's before the court. There's nothing in there in any of those letters that say, hey, by the way, when I was filling out the questionnaire, here's what I did. Mr. Baratlis testified how other jurors were impacted in this particular case, a murder case. So those letters do nothing other than kind of help share that anguish that Ms. Nice had gone through. And the court knows this because the court will recall she testified that this case had changed her. That she broke down on the stand at one particular point. The court took a break. Court put on the record later on that she had been tearful at different times during her testimony. So again, this is all before the court based on that information.
All right.
So again, just going back to the book briefly, because that was submitted as two separate things. One is to her bias and one is part of her financial points. And I just want to sum it up at best. When the court looks at Exhibit 3, the particular book, reporter's transcript, page 305, there was an objection, and the court asked, is there an exception to the hearsay rule? So page 305, starting at line 1. At line 1, Mr. Pat Harris, yes, it's not offered for the truth. In fact, we would dispute the book has any truth to it. So under these circumstances, it's tough to argue how this book is going to be helpful to the defense to prove any particular point, and we would point out when it comes to the financial motive.
You mean petitioner?
Yes, excuse me.
Okay.
It'd be difficult for the petitioner to prove that there was a financial motive on the part of Ms. Nice because there were 6 others, if I recall correctly, jurors that helped write this particular book. They never asked Ms. Nice what windfall was she going to expect from writing this book. So the follow-up question, which would prove in the point, was never asked. All we know is that after the trial, according to her testimony, somebody approached her and asked if she wanted to participate in writing the book, and she did. The one thing that, from looking at the book, there was a conversation that was had with Ms. Nice where she was read, did you say this in the book? She was read this particular quote. This is at page 284, lines 26 through page 285, line 3. We gave Scott the fairest trial he could have. He was innocent in all of our eyes until the evidence proves him to be stone cold guilty. So if we were to submit the state of mind based on what the book was, again, that would be something that shows Ms. Nice did what her job as a juror and based the case based on the evidence. So going into the last particular components, because little man and preconceived verdict come together. There is really no evidence before this court of this whole little man thing other than she may have said that term at different points in time. We have the stipulation about Ms. Anderson that in 2017 she saw a photograph that had a juvenile with something on the clothing that said little man. We don't know anything about that. We don't know who it is, where it is, how it got there. We don't even know if it's the picture that comes when you buy the frame.
Well, that's why I asked about the letters. She uses the term little man in the letter.
Correct.
I'm not sure, again, where I can't point my finger to, but it is in the letters, right?
Correct. There's no denying she uses. She testified during the evidentiary hearing, but the claim that she's fixated because she used that particular term, there is no evidence of that. So then again, the petitioner tried to take that and connect it to the verdict, to the jury deliberations, to show that it was some preconceived notion on her part. And what they said, as the court talked about this earlier, is when Greg Baratlis testified. So again, we have the juror who was there, who said she came in after the juror was substituted, so she's the alternate coming in to take their place. It was never a quote. He said it's something like, and she came in and sat down when she was seated at the table. We've already pointed out, we cited to the court the Bradford case, which says that what she did wasn't wrong, and in fact it's not even cognizable because that's part of deliberations. What she's doing is going and discussing the particular case, and the facts show that she did continue to deliberate with the other jurors, and they reached the lesser verdict as we talked about before. Now the court, I want to go back to one last thing before I wrap this up. The court had pointed out Exhibit 4, the questionnaire, the education issue, where Ms. Nice, on her own questionnaire, couldn't answer the question correctly whether she had training in medicine. So this is, again, her, and she's not trying to hide this. So we can take away all of the petitioner's argument about she's hiding this to get on the jury, because she answered the very prior question, I'm a medical assistant, I'm a CNA. And she answers the question just before, beneath that, I've got medical and nursing training. It's once again just an example of her filling out forms badly. But she's, as you pointed out, question 97A, she also got that one incorrect. And the people would submit to the court when Pat Harris asked the questions about the mother and father, and there were just question marks in those answers, and the court stopped him, I believe Ms. Nice did testify that she doesn't know when her mother was born. There was also another question, the why question, that related to her brother being in prison. So this information about her inability, or however you want to put it, to properly fill out this form, was before all of the parties at this point in time. And Mr. Garrigus had that form before he stopped her leaving the jury box. He wanted her there with her bright pink hair and a mother who did methadone treatment training and a brother that had been in San Quentin for drug convictions. The only thing that we can show is that after all this, Miss Nice is not really good in filling out questionnaires. She made mistakes, she forgot about things, but she did the best that she could. She wasn't hiding anything, which takes us right to a long list, and I'll just go through this briefly. We start with the Cowan case we've already talked about, where the juror said that they weren't hiding anything. Fields versus Brown. In that particular case, that's where the husband didn't tell the court that his wife was raped in a rape special circumstance murder case, and his wife believed the defendant in that case was her rapist. The defendant didn't bring that to, or excuse me, the juror did not bring that to anyone's attention. She gave a declaration to the defense, and it goes on and on. Information bearing on Hillard's testimony in voir dire impartiality as a juror came up after he was in panel. The evidentiary hearing by the district court afforded Fields an opportunity to show that the person was not fair and impartial. He failed to do so. The opportunity to show actual bias is a sufficient remedy and a guarantee of the defendant's right to an impartial jury. That's what this hearing was with Ms. Nice, and the petitioner has failed to show that she was not a balanced, reasonable, impartial juror. Another case, the Hedlund versus Ryan case, and again, these are cited. That court disagreed that you cannot possibly ascertain the impartiality of a juror by relying solely upon the testimony of the juror in question. The court disagreed. Boyette, that was discussed by counsel. That particular case is significant. Again, another, I believe it was a death penalty case where the foreperson, besides having some of the jurors watch American Me, the video, to find out what prison life was like, failed to disclose his prior several felony convictions, misdemeanor convictions, family member convictions, and the court found that the non-disclosures were not intentional and deliberate, that such non-disclosures were therefore not indicative of juror bias, and that Ari was not actually biased against the petitioner. The failure to recollect was not intentional or deliberate. The Cowan case, the fact that the person did not try to hide anything on their questionnaire and did not try to answer the questions in a manner that he believed would increase his chance of being selected on a juror. This is a circumstance where the juror forgot to put something in their questionnaire about being arrested at a mall years before, and the court found in that particular case that the petitioner must prove by a preponderance of the evidence the facts that establish entitlement to relief. And the fact that Cowan argues that the juror intentionally omitted his misdemeanor conviction so that he could serve or be selected as a juror, lobby for a conviction and death sentence, and thereby earn goodwill with the district attorney in the event he violated probation or sought early termination in his probation. This theory, however, is speculative and contrary to the evidence. Much like what the petitioner is claiming here, that she wanted to get on this jury to get Scott Peterson for some unknown reason, for some unknown financial motive. Manriquez, we've already talked about.
Well, the reason, and Mr. Gardner, you can correct me, was that she wanted to get on the jury to punish Scott Peterson for the death of the baby. That's one of the reasons they've articulated, correct?
That's the attenuated claim after you have to go through a bunch of hoops to get to that particular point. But again, we submit to the court, there is no foundational elements to even prove the basis of those particular claims. That, going back to the McDonough case, which is the U.S. Supreme Court, McDonough Power Equipment versus Greenwood, Supreme Court talking about what you must do. A party must first demonstrate that a juror failed to answer honestly a material question on voir dire, and then further show that a correct response would have provided a valid basis for a challenge for cause. The motives for concealing information may vary, but only those reasons that affect a juror's impartiality can truly be said to affect the fairness of a trial. One of the cases that we cited to before, but we think this is important for the court to look at this particular case, and that's the San Nicolas case. It was mentioned by Mr. Gardner this morning. In San Nicolas, a juror was arrested for drug possession. He wrote a declaration for the defense after the trial saying, "I didn't tell you that I had this pending case, and I had agreed to work this particular case off." However, more importantly, this particular juror, when he was 12, neglected to include when he was 12, that he had been the victim of a crime of being stabbed 15 times. He still had scars on his forehead, and his ribs were broken when he was a minor. None of that stuff was admitted, and this was a case where both of the victims were stabbed to death. In that particular case, the court said the proper test to be applied to unintentional concealment is whether the juror is sufficiently biased to constitute good cause for the court to find under Penal Code Section 1089 and former 1123 that he's unable to perform his duty. Whether failure to disclose is intentional or unintentional, and whether a juror is biased in this regard matters within the discretion of the trial court. Except when bias is clearly apparent from the record, the trial judge is in the best position to assess the state of mind of the juror or potential juror on voir dire. And they refer to the Peters test. And the last case was the Wilson case, which we talked about the juror forgetting that they'd been on a capital murder case before. Ms. Nice is much like that particular juror. She forgot a few things. She didn't put them in her questionnaire. There's some debate. We're having a legal argument discussion about whether something is a lawsuit or whether she has to hear a crime or see a crime. The burden has been on the petitioner to prove the material nature, material relevance, and the clarity and the specificity of the questions that were asked. The presumption of prejudice is rebutted going back to Hamilton, and the verdict will not be disturbed if the entire record of the particular case, including the nature of the misconduct or other event and the surrounding circumstances, indicates there's no reasonable probability of prejudice, no substantial likelihood that one or more jurors was actually biased against the defendant. Meaning that the presumption can be rebutted by showing the misconduct was unintentional or due to inadvertence, lack of memory. And we've already talked about the single witness, which Ms. Nice was, proves and rebuts any of those presumptions. But there is one last thing that, when you look at the Cochran case, the Cochran case talked about here the evidence of guilt was extremely strong, and we conclude that the presumption of prejudice has been overcome by the circumstances and content of the nondisclosure as well as the strength of the case. So I would cite the court to the case of People versus Peterson, where our Supreme Court found, and the trailing testimony aside, there was considerable other circumstantial evidence incriminating Peterson. From the simple fact that Lacey and Connor's bodies washed ashore 90 miles from their home, but within sight of where Peterson admitted he went fishing on the day that they disappeared, to the research Peterson did on bay currents in the weeks preceding her disappearance and the fishing boat he bought but mentions no one, to Peterson's inability to explain what he was fishing for in the middle of the day, to his repeated subsequent surreptitious trips to the marina in the weeks after her disappearance, to the many steps he took in the weeks after she went missing, selling her car, exploring sale of the house, turning the nursery into a storage room, that indicated that he already knew Lacey and Connor were never coming back. Even under the most stringent harmlessness standard for federal constitutional error citing the chaplain, it is clear, beyond a reasonable doubt, exclusion of the limited dog-trailing evidence admitted by the trial court would have had no impact on the jury's determination of Peterson's guilt. In this particular case, it was the petitioner's burden to prove, his burden to produce the evidence. There's an old saying about accusations fit on a bumper sticker. Truth takes a little bit longer. In this particular case, we ask the court to follow Shakespeare. Do not cast away an honest man for a villain's accusation. We ask the court to make the required factual findings, deny the petitioner's claim number 1, and discharge the OSC. Thank you.
Thank you. Mr. David Harris. Mr. Gardner.
Yes, Your Honor.
Oh, Madam Court Reporter, do you need a break? Okay, so we're going to take a 10-minute break, please. We'll be back on the record at 3 o'clock. Thank you.
Thank you, Your Honor.
So we were trying to figure out, found it, but we were here. It wasn't sort of in the midst of it, DC at this time.
I know something happened because she wrote it in the second and she was going to return.
I feel like hearing some of those things just like it.
With the exception of the family, we're going to go to the court with the next, media and all, right? For 10 minutes. We're going to go to the court with the exception of the family.
It's been longer than I thought. We're trying to keep you timed over there. Didn't work. All right, it's on.
Yeah, you did start talking faster than I could.
Well, that's because I knew I was having to clear it up.
That's when the outcomes were at. Barely understanding it. And that's just